Thank you for joining us for KTC's first lockdown webinar on planning for uncertainty, critical issues for employers. My name is Simon Lapthorne. I'm a partner in the team and head up the immigration team. I'm joined by my colleagues Scott Worthy and Laura Chapman. Scott, many of you will already know. Scott is part of the Key Brains Trust at the firm, who've been brainstorming some of the most pressing issues in relation to COVID-19. Laura is also a critical part of that Brains Trust and maybe less familiar to some of you. Laura joined us from Freshfields in Singapore at the start of March, so she's only been with us for 6 weeks, 3 of which have now been spent in lockdown. As I say, we're delighted to have her with us and to have her input and insight today. Just a few kind of initial housekeeping points. There is the opportunity for you to ask questions. So at the bottom of the toolbar on the Zoom app, there is a chat function which will enable you to ask questions. We will try and address as many of those as we can at towards the end of the seminar. Just a few acknowledgements as well. I'd like to thank some of our great team behind the scenes. So in particular, Melissa Hu-Davidson, who has assisted with the technology, Mei-Lin Chen, who's drafted some of the materials, and Sophie Preble. I think it's fair to say that for most of us, as we were seeing the new year in on the 31st of December, that we may not have been aware of the growing hold that a new coronavirus was having in China. And I think I can almost certainly say that none of us, as we saw in the new year, would have envisaged that within 100 days, we would be, or half of the world would be in lockdown. And over 2 million people would have kind of suffered from the virus. We're now in the 3rd week of lockdown, and while we're optimistic that the alert level may be lifted next week, and we're still receiving a number of queries from employers about COVID-19. And so in today's seminar, we're going to look at some of the challenges for the year ahead, look at best practice COVID-19 responses, insights into the government wage subsidy. We'll also look at some of the immigration issues that are arising. And so on that note, I'll hand over to Laura, who already is so invested in the firm after only 6 weeks that her name comes up as Kiely Thompson Caisley. So Laura, I'll hand over to you.
Thanks very much, Simon. So as the title suggests, I'm going to speak first about best practice COVID-19 responses for employers. And I'm sure some of you have spotted that's a rather wide topic. And as some of you will have experienced, there are a lot of different responses we've had to adapt to and give quite quickly more recently. So what I've done is I've picked 4 key topics to talk to you about, and I think they're all topical both now, but as we start to move hopefully through some of the alert levels in the next few weeks, if not months. So the first one I was going to talk about is health and safety obligations. Now, I think most employers will know they have fairly robust health and safety obligations under the Health and Safety at Work Act. But in particular, what I wanted to focus on was just looking at the idea behind what duty holders, so PCBUs, so our persons conducting a business or undertaking, have to look at doing in relation to the COVID-19 virus. And the 2 key elements to this that I want to look at was one, how do we eliminate a risk in these circumstances? I mean, first and foremost, this is a health crisis. And if you can't eliminate them, what steps can you do to minimize that? And unless you're in an essential business, so far that's mainly focused on the physical exclusion or the exclusion from physical workplaces. What that's going to mean now under alert level 3 might be something different. And the most interesting part, I think, is the fact that an employer's obligations actually may be different or separate to government guidance on what happens with alert level 3. And I think probably, as most people are aware, the government is probably due to or is currently giving guidance on what alert level 3 might look like. So we'll hear more about that soon. But in terms of what an employer's obligations are, we have to start thinking now about then if you have an obligation to eliminate a risk of contracting the virus, for example, but you are allowed to have workers go back to work, I think we have to ask the question of just because you can, should you? Because your health and safety obligations will overlay what the government guidance is. And where you do decide that actually you must allow people back to work, or you have to have employees in a physical workplace, then how can you minimise those risks? And that's going to involve the usual things that we think about in relation to the COVID virus, and that many organisations were doing even before the lockdown. And that's things like making sure people understand even basic hygiene issues, so having signs up what's expected of them in terms of washing hands, having clear policies around things like when you shouldn't come to work, and again, if they're symptomatic, there's no way you should be coming into your workplace, etc. But it's also now going to involve things like physical distancing in your workplace. So I think a lot of workplaces are not set up to have everyone 2 meters apart from each other, particularly where there's open plan. And so does that mean you have to have shifts of workers or teams, that one team will come in 1 week, one team will come in the next? Even physical layouts, so things like surfaces. We know that the virus stays on surfaces for a very long period of time. So should you be propping doors open so that your employees don't have to hold and open doors? And in that context, if you do prop doors open, is that a fire risk in some circumstances? And are you kind of blocking exit ways or keeping open fire doors that should be otherwise closed? So there's a lot, as you can see, to kind of think about in the context of return to work. But even on top of that now, we're going to have different rules around contact tracing. So looking at contact tracing of every single person who comes into your workplace. And so even a courier or someone else, and even on top of that, how do you even ensure that you have that contact tracing? Because you can't have a logbook and pen, because of course then you have multiple people touching a pen in your workplace, which could also convey a virus. So thinking creatively about how you can achieve that contact tracing as well as that physical distancing is going to be a big part of what employers should be thinking about now that there's a potential we could be moving into that level 3. And again, as I say, the first and foremost, your obligation is to eliminate those risks, not to minimise. So if you can eliminate them by having people continue to work from home, then that may be what you decide to do when you consider your business in the round. So moving on, before I spend too long on health and safety, and I know it's an issue we could spend a long time on, but one of the other issues I wanted to look at is the obligation of good faith. Now, we've seen a lot of news articles, a lot of different issues talking about the way in which employers are reacting to the downturn that they've suffered in business as a result of the COVID-19 outbreak. Now, this is hopefully just a reminder for most people, but these obligations, and particularly your obligation of good faith, doesn't go away in these circumstances. That will continue to be something that employers need to keep in their minds and also to practice. And what does that mean? Well, we probably all know to some extent what it means is you have to act in accordance with your duty of good faith and not to mislead or deceive your employees. And yes, so far so good. But it also means that you have to be active and responsive and communicative with your employees. So it does mean that you need to be staying in touch with your employees. You need to be keeping an open dialogue with them during the lockdown period and beyond. And also, if you are thinking of taking steps that might have an adverse impact on their position, so it might mean that they're either stood down or their ongoing employment could be in jeopardy, then you do have specific obligations to provide them with all the information about a potential decision you may be making in that respect, and to consult with them in relation to the decision. And again, that doesn't go away just because of the lockdown. So it's a good idea to just keep those obligations in your mind as you're going through any planning and processes, and some of which we'll be talking about today. And the third thing is information security. Now, again, there's been a lot of publications around information security, and in particular, the extra risk to your organisation from having people working from home. I think if we take a step back and look at why that is, aside from the obvious hacking, but essentially, in order to protect your confidential information as trade secrets, you also have an obligation as an employer to take steps to secure that information and make sure it's kept confidential. Now, if you think about the way in which a lot of us are working now, and case in point on the webinar, we may be working at home from our own devices and using our own Wi-Fi networks, for example. And we know there are huge different levels of security on different Wi-Fi networks, because a lot of people will use out-of-the-packet passwords that are easily hackable, etc. There's also issues around using your own personal email or your own devices, for example. So as a quick reminder in terms of steps that we would recommend taking whilst you're in lockdown and beyond, if we have employees working from home and or working flexibly, which Scott's going to touch on later. But essentially what we need to do is first and foremost think about your policies. What worked in the workplace doesn't necessarily work from home. You might need to think about rejigging, for example, responsibilities, etc. So employees may need to be more responsible in relation to things like security of their own home Wi-Fi networks, or you need to be putting in place VPNs, etc. that mean or technology sanctioned by the employer. The second thing is think about whether you can have, or you do have, an ability to wipe and lock devices. So obviously it's easier if the phones themselves or the device itself is issued by the employer and you have that ability to wipe it remotely. But much more difficult when it's their own device, and what policies do you have in place around that? I think that's very key at the moment too if we're looking at workforces reducing in size, because we are talking about a population of employees who may become disenfranchised and or disgruntled, and it might be quite important to act really quickly in relation to your IT systems and to be able to preserve that confidential information. But also think about, and particularly moving into what we're going to talk about as the new normal, but moving into that, whether or not you need to have monitoring software to make sure there's no irregularities essentially in relation to your system access. And how does that get supervised in relation to your information? And don't forget, it's not just a question of confidential information being leaked, it's also an issue of data privacy. For example, if you have a lot of customer or client details on your systems that may otherwise be taken. So there are privacy issues around that as well. And the last thing I would just, as a reminder again, hopefully, is if employees have printing rights and access at home, you will need to make sure that employees themselves can't destroy or throw out essentially confidential information with household waste. Because again, that's not secure. So if it is sensitive information, it should be clear that employees should be putting that information to one side and perhaps, if necessary, bringing it back into the office to be shredded or disposed of securely. So that was just a brief discussion about information security. And the last point I wanted to make was just around a multi-million-dollar question of to pay or not to pay. So we've had a lot of questions, and there's been a lot of questions in the media about, do I have to pay employees if they are not able to work? So they cannot work from home and they cannot physically attend the workplace at the time to carry out their work. What I will say is, I'm afraid there is no one-size-fits-all approach to that, and it will depend on the specific issues around your business. And what we can say, I mean, is this, the starting point, as I said, the rules will remain the same. So essentially, you can't unilaterally make lawful changes to your employees' salary, hours, etc. So you can't just impose a pay cut on employees is the basic starting point. From there, I'd also say if you've had a downturn in work such that you can't provide your employees with work, but your employees remain really willing and able to work, then again, your remedy is more likely to be redundancy, and you can't simply refuse to pay your employees. However, in the past, the court has accepted a situation where employees who are not ready, willing and able to work, where there is otherwise work to do, may be in a position where employers do not have to pay them. So there is some argument to say that where employees aren't able to physically attend their workplace and can't work from home, that they are not able to work. Then in those circumstances, there may be an argument that they don't have to be paid. Having said that, that premise hasn't really been tested, and we are already seeing disputes in relation to that, even between lawyers as well as organisations. And I think we will continue to see disputes on that particular argument. That's also impacted by, for example, if your employee can perform partial work, if there's other issues preventing them from working, what your agreements say, and also whether you've applied for a government wage subsidy and when you applied, because of course there were different declarations. Which leads me nicely onto handing over to Scott to talk about insights into the government wage subsidy.
Thanks, Laura, and good afternoon, everyone. I hope you're all safe and well and isolating at home. The government wage subsidy and the essential workers leave support scheme are two crucial tools that an employer can use to get financial assistance. I want to talk about the declarations or the obligations an employer has, but before we get there, in case people are uncertain about what these two requirements or two schemes are, there are two different schemes. The first is the wage subsidy scheme, and in order to be eligible for the scheme, the business needs to have had a 30% decline or a projected 30% decline over a month compared to last year, and that decline has come about because of COVID-19. The amount, of course, everyone will be aware of the amount. For employees who work 20 hours or more, it's $585.80, and the employer receives that amount. For employees who work less than 20 hours, it's $350. The essential workers leave support scheme is slightly different. To qualify for that, you need to have a 30% drop or projected drop, or there is a negative impact on your business. The business must also be an essential business. So it's in one of those categories that is defined on the website, on the government COVID website, such as providing any business that provides essential services, such as an airline or in some respects, even plumbers who are called out to provide emergency services. So there are a large number of essential services, essential businesses, and they can qualify for this scheme. But this only applies with respect to employees who can't work because they're sick, or they're self-isolating, or they're at high risk, like they're over 70, or they have immunocompromised conditions, or they're looking after a person who is at risk at home. So that's a brief description of the two different schemes which you can apply for to assist. If you do apply for those schemes, there's quite an elaborate declaration that the employer must give before the government will hand over any money. And the bullet points here on the slide just refer to the main points in that declaration, but it's a lengthy declaration, and any employer who applies for any of these two schemes should read that very carefully, because there are quite strong commitments that an employer has to make in order to get the subsidy or the leave payment. The first point is really one that Laura touched on already, that the Employment Relations Act and the duty of good faith continue to apply. The law remains the same for everyone and hasn't been suspended. However, of course, what an employer can or should do is defined by what a fair and reasonable employer could do in all the circumstances. And one of those circumstances will be the COVID-19 effects on the employer. The other one that's listed there is to retain employees. Now, this means that for the subsidy period, that's either 12 weeks under the wage subsidy or 4 weeks under the leave subsidy scheme, the employer must retain the employees in their employment. The third one there is the best endeavours to pay 80%. The requirement is to pay at least 80, to use your best endeavours to pay at least 80%. What the website says about best endeavours is that means the employer should try their hardest to pay 80%. There is some case law guidance about this and what best endeavours means, but basically it can mean that the employer would do something that they wouldn't normally do in order to pay 80%. In other words, they may take on some financial liability to keep paying employees at 80%. But the next bullet point is really important as well, that you can't change an employee's pay or hours of work or other terms without their agreement. So although the employer has to use their best endeavours to pay 80%, if they want to pay less than 100%, they'll need the employees to agree. The second to last point there, the subsidy must be used to pay ordinary wages. So you must take the money and use it to subsidise the pay of employees. It's likely this also means you can use it to pay for people's leave, such as sick leave, or bereavement leave, or annual leave during this period of time as well. The last point there is that you can't make an employee take leave unlawfully, and we'll come back to what that means in a moment. Now, if you don't comply with these obligations, then the government may well make you pay the money back, and you agree that if you don't comply, you'll pay the money back. There's also the issue of civil recovery, so the government could sue you for the money. There's also the issue of potential criminal liability if you've committed fraud in applying for the government subsidies. So there are a whole series of obligations an employer has. The other question is, well, what can you do within these rules that the government has set down? The first point is about redundancy. Now, what the requirements say is that you cannot make a person redundant or terminate their employment during the wage subsidy period. But what you could do was launch a consultation process during that period and potentially discuss with employees possible redundancies with a view to making people redundant after the wage subsidy period finishes. The other point here is about annual leave. An employer can't make an employee take annual leave unlawfully under the wage subsidy rules, or indeed under the Employment Relations Act and Holidays Act. But there is a process for getting employees to take annual leave. The Holidays Act tells us that the first step is to try to agree the taking of leave with employees in good faith, and that will be like a mini consultation process. If you genuinely can't reach agreement with an employee, then the employer can direct the employee to take annual leave on 14 days notice. That's only entitled leave though. That's only leave they have in the bank. It's not accruing leave or leave in advance. Either way, the employer should get written agreement about what has occurred, what the deal was, or there should be a written direction to take annual leave. The third point there is unpaid leave. Again, this has been suggested as an option for employees, but again, it will require their agreement. And the other point is about variations to employment agreements. If you're proposing to pay employees less during the wage subsidy period, then you need to get their agreement. During that process of getting their agreement, the obligations of good faith apply, and it's important that you talk to employees openly and honestly about what is being asked of them, give them a written employment variation, advise them that they have a right to take independent advice, and give them time to do that. You should also check what the variation clause says in the employment agreement and ensure you comply with that. As a result, there are lots of innovative ways that you can reduce wage bills during this period of time with employees' agreement. They could work 2 days a week, take 3 days of leave. They could take a wage cut for a period of time. They could reduce their hours and take a wage cut at the same period for that period. So there are lots of different things that you can achieve by agreement with employees. The last point there is just quickly is privacy issues. When you make the declaration, you say that you will inform employees that their information is being shared with the government in order to check essentially that those are really your employees. You also need to tell employees that there's a right to request access to that information, and employees need to consent to all of that before you can apply for the wage subsidy. So with that, I'll hand back to the panel. And
so thank you, Scott.
Back to Laura.
I think if you have applied for the wage subsidy, and we know it's not enough to offset all of the losses that companies are experiencing, and if you have applied for that, it hasn't been enough and you still need to cut costs, what do you think of? And obviously redundancies is one thing that is quite prevalent at the moment and people think about, but what are other ways that you could deal with your employees during decline? And Scott's touched on some of these issues already. So things like agreeing with your employees that they will reduce their hours, so reduced hours for reduced pay, and that might match the workflow that you have. You know, alternatively, reducing salaries. It may be, but there's still a reasonable amount of work, but you're not recouping the same amount of cost from undertaking that work. And that's obviously less attractive because people are doing the same job for less money. But it does happen as an alternative to redundancy sometimes if employers are very clear with them, and also it's done on a temporary basis. Something else we've also seen in the market is people considering their commercial leases. Obviously for the last 3 weeks and will be for definite, most of us aren't using the commercial premises that they lease, and so people have negotiated rent breaks or a discounted rent for at least a month that won't be used. Something to think about in future too is whether you need the same amount of workspace, and again, as Scott will be talking about in a little while, it may be the new normal might look quite different in terms of how many people are actually using physical offices every day. And I know former clients that I've worked for, or businesses even a while back in places in Asia where rent was eye-wateringly high, often thought about having hot desking policies and or a lot more flexibility for their employees so that they could reduce their workspace footprint and thereby reduce their rent. So that's another big cost to think about, and maybe somewhere that businesses have a little bit more flexibility in the future. Again, we've seen employers ask employees to stand down. As Scott says, that has to be by agreement with the employees. But in fact, employees have been more open to that given the state of businesses and potential future economics involved in the business than they would have otherwise. And that's a good way to allow your employees essentially to continue working for you with saving costs, because again, it would be terrible, and I'm sure a lot of you have worked very hard to be in the positions that you are, to have the talent that you have. And it's terrible then if you have to let go of some of that talent for what is hopefully a not too long-term effect on the business. And particularly if you do think the effect is going to be of a shorter term, you do want to hang on to people if you can. And something else we saw during the global financial crisis was deferring new joiners, not necessarily saying we've just got a hiring freeze, we're not going to hire people, but on the basis that we will still hire you, but we're going to defer your start date until, for example, September, December, etc., and moving that out. And in some cases, incentives were provided to new joiners to do that. So to say, we will provide you with a certain almost stipend to get you through the next couple of months that is nowhere near real salary, but then you will join eventually, and we will take account of what you were earning in relation to incentives, etc. So there's lots of innovative ways to do that. Another thing we've seen is keeping people engaged and involved by doing forms of charity or other community work. There's plenty that can still be done online, and as I say, it may or may not relate directly to your industry, but it does tend to help people stay engaged in the workforce. Another thing that's been predominantly in the news is people being redeployed to other industries. So this isn't the same as the kind of classic redeployment in that you ask somebody to do another job within your organization. In fact, what happens is their employment is almost put on hold with their current employer, and they go and work for a totally new employer for a fixed period of time. And one industry that I know has taken on a lot of people is the horticulture industry, for example. So it's apparently it's prime time for kiwi fruit and apple picking at the moment. So there's a lot of people been involved in that. And I think the statistics were something like we now have a 90% Kiwi workforce in the horticulture industry, whereas previously it was more like a 50% Kiwi workforce. So you can see that those dynamics might change, and there may be opportunities to even negotiate with other businesses to take on employees for a short period of time as a way to keep that talent, as I say. Another interesting idea, and something we've done a lot of work on before, is looking at incentive programs. So particularly in relation to things like share option schemes and phantom share option schemes or bonus schemes, essentially, that track the fortunes of the company very closely and give employees some sort of skin in the game. Now, after the global financial crisis and now was a great time to introduce things like share schemes, because unfortunately it meant share prices were at a very low level. But as we all hope, it's not going to stay that way. So actually introducing something like a share scheme now may be very beneficial, because the employee may be able to benefit from that quite significantly in future if they're able to then have a low purchase price for those shares. So that's definitely something to think about, and may offset some of the wage freezes and or reductions that happen, and it might be a way to negotiate with employees around that. So just to think creatively about those incentive structures and the way that we're looking at them. Now, having mentioned, excuse me, the reduction in foreign workers, I'm going to hand over to Simon to talk a little bit about the new immigration controls and what that might mean for employers.
Thank you, Laura. I'm mindful of time, so I'll try and move through the kind of key points relatively quickly. Laura has already discussed the fact that a lot of our employer clients are proposing changes to terms and conditions. And if you have employees that are on employer-specific work visas, there are some important immigration issues that you need to be mindful of. So generally, employer-assisted work visas are subject to certain conditions. So, for example, the visa may state that the visa holder can only work for a specific employer in a specific role and at a certain location. Generally, the positions are full-time, and the visa may also stipulate minimum requirements for remuneration. You may be aware that the most common types of employer-assisted visas include essential skills, talent accredited employer visas, and long-term skill shortage visas. The talent accredited visa and the long-term skill shortage visa both offer a potential pathway to residence. But if an employee is no longer employed in accordance with the conditions of their visa, so for example, if there is a change in their terms and conditions of employment, then that will actually amount to a breach of their visa conditions, and the employer may also be in breach of their immigration obligations. Obviously, the current situation is unique and unprecedented, and our understanding is that INZ or Immigration New Zealand will allow some leniency and flexibility to employers to vary terms and conditions, given the challenges that businesses are facing. INZ has already announced that it will relax visa conditions for a short period to allow temporary work visa holders and international students to assist with essential services during the COVID-19 response, which I think came into effect yesterday. And so that means that work visa holders with an employer-specific work visa who are employed in an essential service can have their hours varied and be redeployed into other roles. Outside of essential services in the health sector, currently there is no guidance, although we are expecting INZ to provide further guidance at some point, as it is an increasingly common issue for employers. So until further guidance is actually published, then I think it's the status quo. Current immigration instructions will apply. Now, if an employer and employee have found themselves in this situation where employment conditions have changed or have been varied already, then the employee should apply for a variation of their conditions or for a new work visa as soon as possible. There's obviously going to be some practical limitations to doing this during the lockdown, and I'll speak more in a moment about some of the practical difficulties. But essentially, I think it's best to seek immigration advice as soon as possible. The second point relates to automatic visa extensions for kind of migrant workers who are already in New Zealand. So following a state of national emergency being declared, the government issued an epidemic management notice, which you may be aware came into effect on the 2nd of April. And the intention of that notice was to address issues arising for temporary visa holders during the lockdown period as a consequence of COVID-19. So essentially there are two kind of key dates. The first relates to temporary visa holders with an expiry date on their visa of 1st of April 2020 or earlier, and who are unable to leave New Zealand. They must apply, if they haven't already done so, for a new online visa, and then they'll be issued an interim visa until they are in a position to return to their home country. Temporary visa holders with an expiry date on their visa of 2nd of April to the 9th of July this year, and who are in New Zealand, will have their visas automatically extended until the 25th of September, and they should receive confirmation of the extension via email. Kind of best practice tip, if you have foreign workers, is that you should ask them for a copy of the visa extensions and keep a record in their personnel files to keep as evidence of their lawful right to work in New Zealand, to avoid falling foul of your obligation not to employ people unlawfully. Finally, then just some kind of, I guess, summary of where we're at and some key points if you routinely hire foreign workers in terms of, you know, what we see is going to happen now. So at the moment, Immigration New Zealand's offices and processing centres have been closed. We understand they are operating a team of skeleton staff, but they are focused solely on urgent applications related to COVID-19 and the lockdown and border measures. If you have employees who lodged a work visa or a resident visa application with Immigration New Zealand immediately before or during the lockdown period, this will not have been processed unless there were exceptional circumstances involved. And I think generally it's rare that those exceptional circumstances will apply. That's generally things like humanitarian grounds. Obviously, this is going to create a significant kind of backlog moving forward and result in longer processing times. And as a result, the government has already announced the temporary suspension of a number of visa categories. So they're no longer selecting or they're no longer selecting for expressions of interest for the skilled migrant category. And they've also put temporary hold on the parent category and the working holiday schemes. And again, you know, the rationale for that is obvious, that they're taking these temporary measures as an acknowledgement that their processing capacity is limited moving forward, and their focus is solely at the moment on essential services. Any work visa renewals that are due after the 9th of July this year will need to be lodged well ahead of time to ensure there is enough time for Immigration New Zealand to process the application and to ensure that your employees can lawfully work in New Zealand. Final measure, obviously, again, you'll probably be aware of the increased border restrictions, and following the government's decision to implement a border closure on the 19th of March, which may be in place for some time, they've also recently announced quarantine measures for all travellers arriving in New Zealand after 9th of April. I will hand back now. I think it's Scott who's going to be looking ahead to the new normal, which for me has meant putting on a shirt for the first time in 2 weeks today and shaving for the first time in a week. But Scott, I'll hand over to you.
Thanks, Simon. There are two parts really to the new normal. There's the immediate new normal, which is potentially level 3, and then level 2, and then level 1. And then even beyond that period of time, how our business is going to adapt to potentially a new working environment. And it will be interesting to see how many of the old ways come back. Will, for instance, businesses located in town still require all their employees to come in to work as they used to, or will traffic and other requirements mean that people stay working from home much more? As we're having this seminar, the government is also announcing details of the alert level 3 requirements and what they will mean. I won't anticipate all of those, although it seems from the reporting that the message is still very much stay at home if you possibly can, work from home if you possibly can, and that a lot of businesses will still have to close during this period. But the alert level 3, and even to some extent alert level 2, do really require businesses to conduct themselves differently. And Laura's talked a little bit about that. Social distancing, working from home as far as possible, hygiene practices, frequent cleaning of workplaces, for example. We'll look with interest at the government guidelines, and I'm sure there'll be more guidelines coming through, and it'll really be focused on what businesses can do over alert level 3 and 2 to minimise the risk of COVID-19 being spread and to minimise the chances of this disease coming back. One of the issues that will come up, no doubt, is privacy in the workplace. And there's been much discussion, for instance, of people downloading apps to allow contact tracing. At the very least, as businesses return to normal, it's likely that businesses to assist with contact tracing should keep lists of people who attend the workplace. And there's also the Privacy Commissioner's advice that some of the Privacy Act rules are relaxed during the state of emergency if you are helping the government to combat COVID-19. The next point just to get on to is flexible working. Obviously, there's been flexible working obligations on employers for a long time under the Employment Relations Act. And any employee can request flexible working at any time, and the employee makes a written request, and then the employer has to consider it, and the employer has a maximum of a month to respond to that request, although you can respond earlier. If you're saying that you can't agree to flexible working, you need to pick one of the reasons in the Act and explain why. The reasons are pretty broad, but basically they're about inefficiency and the fact that performance or customer service will suffer. But it may well be that more employees make flexible working requests. Working from home obviously is going to be, I think, a thing that's going to become even more popular than it is currently, even once we get out of the alert levels. That brings special challenges for employers, in part because when you're working from home, like Simon and Laura and I are right now, that is our workplace. And the employer has an obligation to provide a safe workplace. So it's going to need cooperation between employees and employers to ensure that when they're working from home, people are safe. It's also, in many respects, going to need appropriate technology. And Laura talked about that from information security aspect as well. It may add cost to the business initially if people are going to be set up in home offices. one issue that may come with working from home is the issue of productivity. If it's easy to pop down and watch a soap opera at 11 o'clock, if it's easy to pop out and make a cup of tea, and lots of people have experienced this, there's an issue with kids being at home. Will that affect productivity, or will in fact the productivity gains made from lack of travel and the comfort of working from home mean that overall productivity will increase or be the same? No one really knows the answers to those questions, but it will mean that there may be different ways of working and more flexible working hours and working times for employees working from home. Lastly, I think the social aspects of work need to be factored in here in terms of working from home. Some of us, most of us, I'm sure, enjoy working with our colleagues and want to see them occasionally. And there's no doubt that a happy workplace with a bit of discussion, laughter, and fun makes a big difference to people's lives. And it can be, and many people find it isolating to be at home, particularly during the day, by themselves or and isolated from their social networks and social connections. So it's going to be very important for employers to keep up that work camaraderie through team meetings on phone or video, through discussions, through contact, and as we go forward, you know, Laura talked about the fact that you may wish to have days of the week where everyone is in the office and days of the week where teams are in the office, so that people do come into contact with their colleagues and can feel part of a cohesive work team. So that's all that I have. So perhaps we'll hand back to Simon and we can potentially look at some questions that people may have.
Yeah, thank you, Scott. We've got about 10 minutes left. I think Laura is generally driving this ship, although I'm not sure you drive a ship, do you? So Laura, I don't know if you could field the questions, if you don't mind, please, and then perhaps direct them as appropriate. So either if it's.
So we've got a number of questions that have come through. Please do submit them through the Q&A at the bottom there if you need to. We've got quite a few specific questions around your businesses, and to the extent that we don't answer the specific questions, it may be because they are very particular to circumstances, and do feel free to get in touch with one of us afterwards. But I think that one of the first questions was, what happens if an employee refuses to sign a form asking them to allow a top up from their annual leave balance? So what I imagine this is where the employers suggested or requested the employees take a reduced salary, but will top that up, you know, or let employees use the annual leave to top it up. So for example, if employees work 4 days a week and use 1 day a week for their annual leave, and the question is, should the employer therefore be required to pay them 100% of their pay, even if financially struggling? So there's a number of aspects to that. So Scott, I'll hand that one over to you to start with.
Well, if an employee is on leave, then the way they're paid is set out in the Holidays Act, and the employee is paid either their ordinary weekly pay or their average weekly earnings. Average weekly earnings is relatively easy to work out because it's an average over the last 52 weeks. So that calculation will be relatively easy to work out. There is a question about what their ordinary weekly pay is. If an employee has agreed to take a pay cut, for instance, 80%, then the employer may consider that's their ordinary weekly pay. But the reality is their average weekly earnings over 52 weeks will be higher and probably almost the same as their pay was before they took the pay cut. So if an employee goes on annual leave, the obligation is to pay them under the Holidays Act at ordinary weekly pay or average weekly earnings. Average weekly earnings will probably apply, in which case they'll get very close to what they would have earned the pay cut. So if you're agreeing for employees to take leave, you need to understand that that will be, and potentially will probably be, at a different rate than their new pay cut rate for working at home or working in the business.
Thanks, Scott. Simon, one for you. The question is, can you clarify if you're able to make an employee redundant while they are on the wage subsidy? It says, if it's really the only option, could you get around this by continuing to pay them only the wage subsidy?
Yeah, so I think Scott discussed, the obligations under the declaration, one of which is that you will retain employees for the duration of the subsidy period. You can undoubtedly commence a consultation process during the subsidy period. And, we have had discussions internally as to whether or not you could actually effect a redundancy during that period as well. And I think the conclusion we reached was, if you gave the declaration in good faith that you would retain employees for the duration of the subsidy period, but then there has been a significant kind of decline in revenue or further unforeseen circumstances which you didn't envisage when you sign the declaration, then conceivably you could make redundancies, and then you'd be required to repay the subsidy amount in respect of those individuals. But Scott highlighted the fact there is also the potential issue of criminal or civil liability for breaching the declaration. So I think if you hadn't made any misleading comments at the start, then I suspect the criminal liability, or that there would be no criminal liability, but you can't rule out the possibility of civil liability. So I think it'd be risky. I think the most prudent course is probably to start the consultation period. One other possible solution is that you start the consultation period and potentially you could give notice and agree extended notice, which factors in the wage subsidy period. That might also be an option. Scott, I don't know if there's anything you want to add or clarify.
Yes, I mean, I think that's all right. The issue might be that if you consult with employees now about redundancies that might take place after the end of 12 weeks, things could have happened in between. So it will be, if you can wait, and if you can run the redundancy consultation process right at the end of the 12-week period, that would be a more robust process, because at that point, the employer and employee will know the situation, will know why you want to make changes, and will understand that the lack of economic, the economic effects of the virus mean that the business needs fewer staff, for instance. And then you could consult right at the end of the 12-week period, but not actually terminate employment until after the 12-week period has expired. And you could, in fact, give notice within the 12-week period as long as employment didn't terminate until after the end of that period.
Okay. And so Scott, coming back to you again on some of these, but it was just the issue that you touched on earlier. What happens if a person doesn't provide their consent for private information to be used for the wage subsidy application? Are they setting themselves up to be considered for redundancy?
If they don't, then the declaration says you can't apply for them, and that should obviously be made clear to the employee who refuses consent. If it would be problematic to run a process with just that employee who refused consent and say you're redundant. We'd have to think about the specific circumstances of everyone, but of course it needs to be a genuine business reason for the redundancy, not the refusal of the employee to agree to the wage subsidy. So that would be a tricky one, but it's possible that if you had a broader redundancy process, that might involve people who had not given consent, and of course you wouldn't be obliged to keep those people in employment because you hadn't agreed that wage subsidy condition. But you'd have to be really, really very careful to justify acting against an employee who refused consent. There need to be a very, very strong business case to overcome the allegation that the reason you're making this person redundant is because they've just refused to give consent.
Okay, thank you, Scott. I think we've just ticked over to the 1 hour point. We appreciate that that many of you will have lots of pressing questions, and we're sorry if we haven't had a chance to get to those today. I would just draw to your attention that there is information available on our website, which is www.ktc.co.nz. In addition, if you don't already follow us on LinkedIn, we do post kind of regular updates as we receive new information from the government about the wage subsidy or other matters relevant to the COVID-19 situation. This webinar has been recorded and will be available on our website as well. So it just remains me to thank you all for joining us, and we hope that we may see you soon in the future in person at a future event. But if the restrictions do remain in place for the foreseeable future in terms of social distancing, then we will be running further webinars. Thanks all.
Thanks very much, everybody.
Yep. Thank you all. Goodbye.
Bye-bye.